This is part of our estate planning series. There's going to be a part 1, part 2, and part 3. Part 1 covers estate documents. Estate documents are the foundation of a great estate plan. They are documents that are done by an attorney, or in my opinion, should be done by an attorney. The majority of Americans have no estate plan. A survey done by LegalZoom found that 55% of Americans don't have a will, and also that 62% don't have powers of attorney, which in my opinion is just as important as a will. So you might ask yourself, why don't people have legal documents? And I think there's a few reasons, but 3 that I found is it's the easiest thing in the world to put off. Most people intend to have it done. They're sure they're going to have it done. They're just going to have it done tomorrow or next year or when this happens or that happens. And so it's kind of our goal is to kind of help you get off the fence on that. Most people don't know what they really need, and we're going to talk about that today. And then most people don't only not know how to talk to an attorney, they don't know what the answers are, and they're afraid that there will be questions asked that they don't know what the answers are. And so we're going to try to give you some information on that. A will is a legal document that tells the state what you want to happen to your property after you pass away. A will has no power whatsoever while you're still alive. And there's certain things that you will need to know when you talk to an attorney about doing your will. Of course, you'll need to know what you want to happen to your property after you're gone. In addition to that, you will want to know who you want to be in charge of passing it out. That would be your executor if it's a male. It would be your executrix if it's a female. The most important thing a will does, in my opinion, is if you have minor children, it tells who you want to be the legal guardian of them after you pass away. Now, a lot of people that see this may be senior citizens and they don't have that problem, but your children do, if you have grandchildren. And so those are the things that a will does. So when you talk about a will, if you have minor children, you're going to decide who you want to take care of those minor children if something happens and you're not there and you're not alive at the time. But the 2 things wills do for everyone that has them, it tells who you want to what you want to happen to your property after you're gone, and who you want to pass it out. Now, when you talk to an attorney, you're going to want to know the first person in that executor or executrix position, but you also want to know who you want as a contingent, or you might want them jointly, but I would say you would at least need 2 people in there. I wouldn't go to an attorney with just one person in mind. So that's a will. There are other documents that you need. One is a health care power of attorney. I say you need. That's my opinion. One is a health care power of attorney. A health care power of attorney tells who you want to make legal decisions, who you want to make health care decisions for you when you're not there and be able to do it. For example, if you're in a coma, or you've just had surgery, or you're unconscious, or you've got dementia, whatever that is, that's going to be the person you want to make the health care decisions for you. So first of all, you need to know who you want in first place making those decisions. You also want to know who you want in second or third place, even if you have somebody to make that decision. Now, you can have joint people that do that for you. Next, I would say you want to know about a durable power of attorney. A durable power of attorney is a business power of attorney that allows somebody else to make business decisions for you when you're not able. It could be the same person that's going to serve on your health care power of attorney. It may not be. You may have somebody in the family that's very good with healthcare decisions, but they're not good with money. And you may have somebody that's really good with money, but they're not so good with healthcare, or perhaps they're out of state somewhere. When I thought about this, I would be thinking of someone that would be close, not in another state, to be on my healthcare power of attorney, just in case there's an emergency there. So the healthcare power of attorney is going to make healthcare decisions, and durable power of attorney is going to make business decisions for you. Now, there's a little bit of a red flag I would put up here. When you talk about a power of attorney and you want to talk to the attorney about this, if he wants to make it a springing power of attorney, a springing power of attorney is a power of attorney that only springs into action when you're incompetent. The reason I mention that is this: if it's only going to spring into power when you become incompetent, who decides who you're going to become incompetent? Do you have to go through a competency hearing at the clerk of court's office and be declared incompetent? If you do, that can be very humiliating for the family and the person. Sometimes people have strokes. Sometimes people have different types of dementia, and they get very paranoid about anybody doing their business for them. And there might be somebody today that you'd look at and you think, well, I trust that person with my business. I trust them to do the right thing, and they may deserve that trust. But if you have a stroke or you have some forms of dementia, would you still trust them? Would you want to be dragged into the clerk of court's office while they sit and prove that you're incompetent? So if they say they're going to do a springing power of attorney, your question might be to them, who is the one that decides whether I'm competent or not? And if it has to be the clerk of court's office, it has to be a judge somewhere, then you might not want that power of attorney. That's up to you and the attorney to do that. But when it comes to a durable power of attorney, who do you want to make healthcare decisions for you? Need a first and second place. When you're talking about a durable power of attorney, who do you want to make business decisions for you? That's first and second place. Then there's a living will that a lot of people have, and a living will says what you want to happen to you in end-of-life situations, where you're in a coma and you're not coming out of that coma, or you've been diagnosed with a terminal illness, and to a high degree of medical certainty, you're not going to live very much longer. Do you want heroic measures? Do you want to be put on a ventilator? Do you want, if there's no hope, and that's when this is supposed to happen, do you want feeding tubes? Do you want hydration through tubes? Those are the questions that you need to know when you talk about a living will. Now, there is something you need to know about a will, and when you go back up to the will, if you have a will, anything that passes through probate, anything that passes through the will is going to pass through probate. Probate is a legal process of passing out your property at the time of your death. And there's some drawbacks with probate for some people, and some people, they don't mind them at all. They don't think they're a big deal. There's the time it takes to probate an estate. There's the expense of probating the estate. And there's the fact that anything that goes through that will and goes through probate is public record for anyone to see. Okay? One of the ways that a lot of people will use to avoid the probate process is called a revocable living trust. It's a trust that allows you to own the trust, to control the trust, and be the beneficiary of the trust. The difference is when you become incompetent or eventually pass away, your property, it's got some extra benefits to it. One of the benefits is that your property doesn't go through probate. So it saves some expense on that. It saves some time on that. and it's private. Privacy comes into play for a lot of people. They don't want the state and everyone else knowing what they're passing out and who they're passing it out to. So it's important to some people. Some people in particular, gun owners, don't want their property listed on a 90-day inventory sheet to tell the state what guns they have and who's getting them. So that's a thought on that. So anything that is in the trust and passes to the heirs through the trust generally does not go through probate, and you might want to talk to your attorney about that. It has some other advantages. Let's suppose that you have minor children, or maybe you've got somebody in the family that's not very good with money. At that point, you can take and you can put the property in the revocable living trust, and you can dictate when they get it. If you pass it through a will and the person is 18, in North Carolina, age of majority, and I imagine it's similar in other states, whatever you send them, they're going to get immediately. If they're younger than that, the money is going to be held in trust for them until they turn 18, then they're going to get it all at one time. But let's suppose you've got somebody that you don't want to have it all at one time. They're not very good with money, and they might just go out and blow it all at one time. Or they're a child, it might be a grandchild or a child, and you don't know what they're going to be like when they're 18. Are they going to blow it all at one time? Are they going to use it on something that would hurt them? So you have to look at that and say, well, I might want them to have theirs at 21, part at 25, part at 30, or you can do it however you want through the trust. You can't just do that with a simple will. So that might be something you want to think about. So when it comes to a revocable living trust, you can dictate the time. It should not go through the expense of probate, and it's private. There's not a public record of it that's in an estate folder somewhere. So when it comes to this, these are the things you're going to want to know. First of all, you're going to want to know who you want to manage this property. In this case, it could be managed for a number of years. So if you've got little Johnny and he's your grandson, and he's 5 now, and then you passed away suddenly in a car accident or whatever, that money might be in that trust for years. Well, you need somebody that could manage that money, manage those assets. That would be your successor trustee. You need, in my opinion, not just one person, but more than one person. And sometimes you might want to use them jointly to manage those assets in the trust. That's your successor trustees. Then you're going to want to know who you want to have your property. Okay? So it's always good to know who you want to have it, and not just who you want to have it, but you're going to want to also know what happens if something happens to that person. Who do I want to have it in that case? When do I want to get them? If I have a son or daughter, do I want them to have the property, and then if they pass away, their children to have the property? Or would I want it, if I had a son and a daughter, if one passed away, I want the other one to have all of it? That's just a thought there, but it's something you need to know. And then, when do you want them to have it? Do you want them to have it immediately? And it doesn't have to be the same for everyone. Or do you want them to have it a little bit over time, or do you want it to be held to a certain age? Those are the things that you need to know before you talk to an attorney about a revocable living trust. So it's important that you find an attorney that you're comfortable talking to. These are some of the questions that you'll want to know. And these are some of the questions that you will have the answers to, and it'll save you time when you go there. If you have a good idea of what you want and how you want things done and who you want to be in charge of this or that or the other. But if you don't know a good attorney and you want to call our office, we can maybe give you some pointers on how to find one. All attorneys are not the same. Some attorneys just do simple estates. They do wills and powers of attorney, that type of thing. Others specialize in trust. Others, when you get a complicated estate, you might look at an elder care attorney. It's going to be much more expensive, but they specialize in things like Medicaid planning, those types of things. So if you don't know what to do or who to call, give us a call or send us an email, and we'll be glad to try to help, at least give you some idea of how to select an attorney. If you're in the Hickory area and you want to call the office, we'll be glad to make an appointment. We have attorneys that we work with as well. So hopefully this has been helpful to you. If there's anything we can do, just give us a call at any time. This is part one of a 3-part series. This is on estate documents. Estate documents should be done by an attorney, and that's important for everyone.